picture to look at when you're bored. So pretend you're on that river ride, floating down, you know, and do a little and kind of zone out if you need to, because we're right before lunch. I'm thrilled to be here and talk about guardianships, especially in the context of capacity and all of the medical information that you've been hearing. It's really wonderful to have doctors and lawyers in the same room in a peaceful setting. When I started thinking about this and going through it, I thought, well, if I'm going to talk about guardianships and alternatives, I really have to talk about the levels of capacity. And I thought, well, maybe I can't do this when I have all these experts coming in and talking about capacity, because they really know what they're talking about in the doctor zone. But I think what, in the past, as an attorney who practices in guardianship, what I've realized is that medical terms of capacity and legal terms of capacity are this really nasty marriage. And so when you're trying to fit the medical assessment tools into the legal boxes for capacity, you really come up with these odd conclusions. And so having just heard some wonderful speakers on capacity and assessment, I want to try to take what they have said and put it into our context on the legal field about capacity. First of all, the last question that was asked was, well, I don't really understand the medical capacity versus the legal capacity. And so one of the things I want to talk about is, what are the capacity levels? What are we talking about? The law doesn't have a black and white, now you have capacity, now you don't. The law doesn't look at it as a now you do, now you don't. That glass half full, half empty analogy is really, really good, because we look at it as a continuum. You have this spectrum. Over here, we're functional. Over here, we're not functional. And then there's everything in between. And one day you may be up here, and the next day you may be down here. You know, it's like the new studies that show that driving with lack of sleep is just as bad as drunk driving. So it's that capacity. Where are you on that spectrum varies any given day. But when you're looking at the legal terms, you look at it from how does this work? And so on a practical sense, what does this mean? Let's start out with the most extreme, and that's mental health commitment capacity. And this is extreme because of the remedy. The remedy is you're put in a locked unit, and you lose all of your civil rights, and you're temporarily in a mental jail, for lack of a better word, where you are receiving treatment, probably against your wishes. So looking at that, there's a very extreme level that you have to reach of incapacity, and the extreme level is a danger to self or others, and in a deteriorating condition. That's the mental health standard. It doesn't have anything to do with the guardianship standard. So remember, when you're looking at a medical affidavit and you're trying to fill it out, or you're talking with your physician and you're the one who's having to describe it for them, that when we're talking about a commitment standard, that's a much different standard. That's someone who's in danger to self. It may be suicide, it may be failure to take medications, it may be that they're total self-neglect, they're not feeding or dressing or bathing themselves. And then you're over here on this, yes, they're a danger to self. Okay, what do we need to solve that? Are they in a declining position? I had a case this week with a lady, this has been going on for years, and she has been in a declining position. And the family, I think one of the things I've also learned is that families are oftentimes not in a position to recognize the severity of the mental illness or the severity of the dementia. This lady, 2 years ago, I got the call her gas line had been cut off, and she didn't know how to get it back on. Well, APS got involved, they solved the problem. 6 months later, there's another one. At that point, we're getting the calls. We're going, you know, this is really clear. There is an ongoing problem. This is not going to be solved by temporary interventions. Yesterday, this week's problem was the toilets had all overflowed, and she didn't recognize they were overflowing. The assessment came back, she had no judgment skills. The family's like, well, you know, she's okay. And that's where you run into these problems. So when you're looking at mental health commitment, this lady probably, with families not recognizing it, the other thing that I've recognized is that the families have been in these positions for long, long periods of time. They've lived with Mama's mental illness. They've lived with the fact that Mama's always been peculiar. She's never participated in the family activities. I even had the case where a medical professional and an attorney were held at gunpoint by the family member, and They came in for help, and we were getting help for Daddy, who needed hospitalization. Well, Mom had been the one holding him at gunpoint. And when Mama came into the courtroom, I said, you need to go downstairs and swear out a mental health affidavit. It's real clear from what you're saying, there's something wrong. And they're like, oh no, there's nothing wrong with Mom. They had just been held at gunpoint for 24 hours. You know, this is where the family lacks the information and the assessment tools to say, there is a problem. So mental health commitments are extreme, and you as medical professionals are going to be hearing all the clues, and a lot of times the families are not going to recognize the clues because they've lived with them for so long. So as the intervener, I call you the gatekeepers. You're the folks that are seeing these people come in. And when you see those signs, you know, the first assessment is there an underlying mental illness? Can we treat it on an outpatient basis, or do we need the radical intervention of a mental health commitment? And that is a process done through the DA's office, through the Bexar County Justice Center. And you or a family member have to go down as a first party who has witnessed the problem and swear out an affidavit. Then the Sheriff's Department goes out and they pick them up. And again, the first standard for capacity is that for mental health commitment, danger to self or others, and a deteriorating condition. The other standard that you're probably going to jump now down to one of the lowest standards, and one that's real familiar because you'll oftentimes get the call from an attorney who says, Mrs. Jones wants to make a will, I'm a little uneasy about it, what do you think? And so that has a different standard. And that standard is, does this person know their bounty? Do they know the natural objects of their bounty and who should receive them naturally? And do they know who they want to leave it to, like Sally Jones' caregiver? And can they keep it all together in their head at the same time? So if they can do that, they have capacity for making a will. So that's your second level of capacity. The next level is one that's more important to us in what we're talking about today, and that's capacity for business affairs, or capacity to contract. And this is the one where, do you have the capacity to undertake your business and know what a reasonable person would do under similar circumstances? And again, we're back to that reasonable person. That's a good legal term. And reasonable circumstances, what that may mean for someone who has $20,000 in the bank is very different than what it would mean for someone with $2 million in the bank. And when that $2 million person is wanting to give it over to Joe Blow's campaign fund, which happened to me several years ago, that's probably not a reasonable thing. And it's probably not reasonable for the attorney who called and said, is this check valid? And I'm not sure who was lacking capacity in that case. But when that's the whole estate, that's not a reasonable action. And so what you have to assess in that business capacity, again, it's a floating, but it's a standard. And so when the attorney's calling you, one of the questions is, how much business are we talking about? And I'll go into that in a minute. The next standard is that for healthcare directives and healthcare decisions. And the simple answer is, there is no legal standard. So, where does that put us? What does that mean? For guardianships, we do have a standard. I should say there's no defined standard. I think we all have some standard in our head. But for guardianship purposes, the standard by statute is the person unable to care for him or herself and manage their individual properties and care decisions? And if the answer is no, then they're a candidate for guardianship, possibly. If the answer is yes, then they don't belong in a guardianship. So then it comes down to looking at this on a sort of scaled level, because guardianships are not black and white. We're looking at that continuum. Where does someone fall on that continuum? Are they down at the end where they're almost comatose, or are they up here high functioning? And I'm going to tell you the high functioning ones are the really hard to assess, because they have their good days, they have their bad days. As a medical professional, when you get the call from us, the first thing you say is, I can't release that information, it's private. HIPAA told me no. And I'm going to tell you, go back to your hospital attorneys and your medical association attorneys and ask them, is there a standard for best interest of the client? Because there is, and it's been there all along. If there is no other option and it is in the best interest of the client to let go of some of that then you need to work with the family and the attorneys and do it if it's the reasonable person under the circumstances. So yes, you do have to guard that privacy, and don't blab to anybody who calls. Test it out, make sure what's going on, but do be reasonable and talk with your legal advisors about what standard your facility uses or your hospital uses so that you're releasing information appropriately. Find out what's going on. And I know physicians, you have those 5-minute intervals or you miss your payment quotas, and we're all under that kind of billing pressure. But it's really important. I think our first speaker talked about that and talked about, you know, what are they functionally able to do, and that's what we're asking you to tell us. Can they pay their bills? Who's trying to help them? Is this a reasonable family member? Doctors are oftentimes the point person, and you see the caregiver bringing them in. The caregiver is your reporter. And so oftentimes you become involved in the abusive situation without realizing it. So probe beyond that. Who are the other family members? What's going on? Who is this caregiver that's here with them? Find out who the other players are. Is there an attorney involved asking for this affidavit? Is this a family member who's trying to seek some legal action? Are there conflicting family members? What's going on in those situations? And right before I came up, I discovered that Russell was using the same case study at the end of the day that I'm using in this speech. So you guys are going to get to know Mrs. Smith really, really well today. Mr. and Mrs. Smith had a long-term marriage, and they were living at home with 24/7 caregivers. Mrs. Smith had recently fallen, and I'm going to tell you, I've added facts that aren't there because I wanted to make it perfect for my talk. She had recently broken her hip and had come home, was not cooperating with rehab, and had become progressively abusive toward her caregivers, toward her spouse, and toward her other family members. She'd also gotten to the point where she had an alcohol problem, and she'd started seeking alcohol again. She was firing the caregivers who'd been in place for a long time, but who were not cooperating with her getting alcohol. And meanwhile, the kids had their power of attorney, they had their medical directives, and they had full cooperation with the medical and the financial side. So that's not the issue. And I think this is one of the hard points. You know, they were talking about the banker who got involved. One of the things that tips you over the edge is the bankers may or may not cooperate. If they don't cooperate, you have a problem. If they do cooperate, you may have a problem because they're releasing the Social Security check to the son or daughter or to the caregiver or whoever. The first step is to call the fraud department. The banking institutions all have local fraud or all have fraud departments. The local banks have local people who deal with that issue, and they are much more aggressive. If you're with one of the national banks, you're going to have a heck of a time. They just don't do it. But they do have fraud departments, and they are supposed to be doing it. So with Mrs. Smith, she had begun having some of these signs, and the question becomes, okay, she's being abusive, she's threatening suicide, she's seeking alcohol, and her health is going downhill because she's not taking her medications. Do we have a mental health level commitment? And the answer may be maybe. And what you've got to do is figure out what are the least restrictive alternatives. We don't immediately jump to guardianships. Guardianships are the last solution. Remember that she's already got things in place to handle everything. But the downfall is these are for positive actions. She's doing the negative actions. She's refusing. So you can make the decisions for her, but she's refusing the care. She's refusing the caregivers. And if that happens, that's where you start to fall between the cracks. So in a case like this, when you're evaluating it, one of the things that you look at is this a sudden deterioration? Is there something that we can do to prevent further deterioration or bring her back to a higher functioning level, and thus keep her at the non-guardianship level and keep those directives and financial directives functioning? So the first step with the family is to assess whether or not the mental health commitment might bring her back to a functioning standard level that she could go back out into the community. So while it is one of of the most extreme actions. It also may be the intervention that allows you to medicate her and get her to that stable level and thus enable her to go back out and function in the community without a guardianship and leave the alternative situations in place. So let's say Mrs. Smith goes in and she has a commitment. At that point, the question is, now she's coming out and she's refusing care again and she's firing the caregivers, and the physician is saying, you know, she really can't go home. She needs to have a higher level of care that's being given in the home, and it's not cost effective to do it at home under the circumstances. So at this point, you're looking at, okay, she's refusing placement decisions. Now, this is the tricky part for you in the medical profession. While she's in the hospital, those medical directives enable you to work with the family who places her into a non-medical assisted living facility. Okay, that's great. But now she's out in the assisted living facility, medical directives aren't effective for non-medical decisions. So the decisions that are needing to be made are decisions about her residential care, whether she stays there, and she's trying to check herself out. So we start getting the calls from the facility. If you don't get a guardianship, we're going to have to let Mrs. Smith go home. That's the point on the personal care side where you may be tipped over the edge and you have to go to court and say, Judge, we need help keeping Mrs. Smith in this level of care so that she's getting what she needs. So it's the need that's happening and where the directives are failing, and that's where you wind up with the intersection of the guardianship. To start the guardianship process, and that's on the personal side, and again we look both at two sides, financial and personal. To start the guardianship, we have to have a doctor's affidavit, and I'll confess my technical incapacity here. I thought I had emailed the affidavit, but it's not in your materials, and I apologize because I wanted you all to see it and walk through it with me. But let me go through the questions that are on that affidavit. The first thing that's going to be asked is, what is this person's diagnosis? And you're going to write something like moderate dementia. And then it's going to say, what's the degree of incapacity? And you're going to say, I already said it's moderate dementia. And then it's going to say, what's the history? Mrs. Jones came out of the hospital and exhibited moderate dementia. And then we're going to get, what's her ability to communicate decisions? And then we get answers like, she has moderate dementia. And so we're going, okay, what do we do with Mrs. Smith? How do we know where that moderate dementia is? And so this is where the court affidavit has a list of very helpful things. And what happens is it says, if she's totally incapacitated, you don't have to check these. But every doctor goes through and checks them. And I think it's because it is a helpful checklist. It helps you realize what we're trying to do is take your diagnosis of moderate dementia and translate it into everyday things. And so the things that we're asking about are simple things. Can she pay her bills? Is she able to make her mortgage payment, pay her rent, pay the CPS bill? Okay, probably not. The next one is, if there's a problem on the CPS bill, is she able to call CPS and work out that problem? No, she's moderate dementia. Can she write a check and understand what that check is and what she's spending the money on? You sit there, I don't know, I didn't ask her, but let me try it. Oh, no, she didn't fill out the check correctly. Or she couldn't keep it all together. Okay, no, she can't do that. And then we start asking you, how much money can she handle? And that's when I get the phone call. And I say, okay, well, when we're talking about how much money she can handle, can she make a simple decision, like could she go spend $100 and choose a dress? Well, yeah, she could probably do that. Okay, can she afford to lose $100 if she's buying a dress every day? Well, no, she can't. Could she make a decision like a $500 or $600 decision, like buying a washing machine? And then you start saying, well, what do you have to do to buy a washing machine? Okay, she probably should check with Consumer Reports, maybe shop around and get the best price. You're saying, no, she couldn't do that. Or maybe she can do that with moderate dementia. And again, that's where that line starts getting iffy. And then you go, okay, well, can she do a $2,000 decision? Can she do something like have her house painted? Is she able to understand that I shouldn't take the door-to-door salesperson that came by and offered to paint the house for $1,000? I should get some bids, and I should find out get some references, and do some checking. Well, no, she probably can't do that with moderate dementia, so she can't do a $2,000 decision. And then the next one would maybe be a $10,000 decision. You know, like buying a car. Cars for men are the favorite thing. I think I've avoided several dozen car contracts over the years because people go out and they buy the new car, they spend every cent in their savings account, and then all they have is a car, and the family's going, we can't even pay the light bill. Well, those are the kinds of decisions that get into that $10,000 decision. The $2 million client could afford to go buy the van. And you know what? Maybe we need to let that kind of decision stand. But we can't let her write the $2 million check. So when you're going through that medical affidavit and you're saying how much money can they spend, think of it in practical terms. If I'm writing down she can afford to spend $1,000, think about what that kind of decision is. A $1,000 decision usually isn't addressed unless you're buying the designer pants that some of my clients buy. But for most people, that $1,000 decision is a more complicated decision, and so make sure that they have that ability. And think about what can this person afford to lose. If they can't afford to lose $1,000, then by golly, they shouldn't have that ability if they're not understanding it. If they can, and some of my clients can, then let them have it. A lot of times it's a dignity and an honor, and a lot of times what we'll do in the guardianship process is give them a bank account with a finite amount of money, and so be it. When they spend it, they spend it. And merchant beware. The next issue is, can they apply for Medicaid, VA benefits, and other government programs? Now think about it. How many of you filled out a Medicaid application? Okay, so can someone with moderate dementia do this? And if they can't, then remember, they don't have capacity to do that. The next one is, can they explore housing alternatives? And again, this is usually where we're running into the problem. Because we've just come out of a hospital, we're needing rehab care, we're refusing rehab care, we're checking ourselves out of the facility, so no, they probably don't have the ability to make a housing decision. And the next one is, are they able to make employment decisions? And I've had many people come in their 70s who have jobs or volunteer jobs where they may be being taken advantage of because they don't have complete capacity. And so think about it. Could they negotiate with an employer that I can only work 4 hours a day because my back hurts? And if they can't, please, please, please don't say they can do these sorts of things. And the next one on the list in our medical affidavit is, can they consent to psychological and psychiatric tests? And I've never met a doctor who says no. So everybody gets to consent to psychiatric testing. And the other is medical treatment, and that one I get more circumspect answers on. But I think in reality, oftentimes medical treatment is actually something people can consent to. And I had a psychiatrist once explain in testimony, and I thought it was a very good definition because it goes back to what can somebody do and what can't they do. Core values stay with people even through dementia. Those long-term, long-time ingrained core values. So when they're making a major decision, they are more likely to have capacity than when they're making a minor decision. So when they're making the major decision about consent to treatment, they may be more likely to have capacity because that's going to relate back to the core values of do I or don't I want life support. But when it comes to the little medical decisions like, do I buy this prescription? Do I go to the doctor's office today? Can I set that appointment and follow through on that appointment? They probably aren't going to have capacity. And so, yes, they probably are going to have capacity to consent to psychiatric treatment or maybe even breast cancer surgery. But they may not be able to have consent on the follow-up care, whether or not they have radiation and chemo, and all those they're not minor, but all those decisions that go to support that care. And so when you're filling out that doctor's affidavit, it's real important to think about that. The final issues on the affidavit don't usually apply to the elderly, which have to do with consent to education, consent to military service, and consent to NHMR facilities. The one thing that is on there, though, is consent to insurance contracts. Please look at that carefully. When people are consenting to insurance contracts, one of the things that falls in that category is annuities. And annuities are one of the major fraud perpetrators on the elderly, annuity salesmen. So when you're saying that they have capacity, remember that they may be putting their $100,000 CD into a $100,000 annuity that's not going to pay out for 10 years and they can't withdraw from without a 10% penalty for 5. That's probably not a good idea for an 80-year-old person. So this doctor's affidavit and these questions are the practical questions that you're going to be asked to answer from the more esoteric exams that you're doing. You know, the mini-mental, the exam that Dr. Calowish described this morning. These are the things that we're going to ask you to say are the more subtle things. What can they or can't they do? Now in guardianships, as I've said, we divided up into 2 categories, the estate category and the person category. And when we're looking at least restrictive alternatives, the things that we're going to start with are what we've already talked about, the power of attorney. A power of attorney, the ability to contract and to sign a power of attorney. And when we're talking about contract, that goes back to how much money can they handle? What can they do? Can they make practical and reasonable decisions? Well, they can't probably sign a power of attorney if you've just said they don't have the ability to make good decisions about their money. Because what that means is we don't know if the son who's in your office is the good son or the son who's going to the bank taking the Social Security check every month. So be circumspect about that. If you just said they can't handle money, don't check that they can sign a power of attorney. The power of attorney does have accountability. What this does is it enables someone to step in and pay the bills for the older adult. They have accountability to that older adult, and they have to provide them with how they're spending the money. But if the person doesn't understand how their finances, they're not going to be able to evaluate whether the money's being spent well. So it's important to make sure that they have the ability to understand that document and they're appointing someone who's trustworthy and honest, because that's going to be where we run into problems. The next issue is that those powers of attorney are between the person who's signing them and the person who's acting. They aren't between the bank. And yes, we can call the banks and try to put pressure on them, but it may or may not work depending on the bank and who answers the phone, and whether it's the paralegal at Bank of America or the person who's worked with the family forever at one of the local banks like Broadway or Frost and knows the family and the whole situation and knows that Mrs. Jones signed this because she's always trusted this son. And those long-term relationships are going to influence how those powers of attorney are recognized or not recognized. A more powerful tool that we often use are what are called trusts. And Russell alluded to this. I suspect it was a bank trust officer. Generally in a trust, a good trust will have provisions that outline when a person can or can't handle their affairs, that they have to step down from being trustee, and then empowering the trustee to act on their own, or a bank trustee or a family trustee to step in. So you as a physician may be asked to certify, usually it takes 2, whether or not the person has capacity to handle their financial affairs. And if they don't, then it may trigger that trust stepping in, and you have the ability to then have a third party step in and pay the bills. The things that fall through the crack on the financial side, unlike housing and non-medical decisions on the personal side, are when the older person's writing the $2 million check to the campaign fund. They really love the Jamaican lottery. They get those Africa, put money into your account for a day and you'll have $1 million mailings. They also send them out email. I think you're probably getting those too. When they start gambling and getting involved in these fraud cases, that's when powers of attorney and trust fail. Because those documents only enable people to act. They don't enable people to prevent actions. That would take a restraining order. And so without that ability to prevent, a lot of times you may wind up down at the courthouse in a guardianship to prevent action. When we're looking at these alternatives, we're going to first go through and say, okay, Mrs. Smith is refusing her housing. She's wanting to revoke her power of attorney. And so what are we going to do to ensure that it stays in place? And so a lot of times what we'll do is we'll say it's an emergency because if we don't have someone in authority, she's going to go home. And not only does it harm her, but it potentially can cause harm to her husband, who we know she's been physically and mentally abusive to. So those are the times when we wind up having to get a court intervention to help with placement from a medical facility into a non-medical facility. So the process becomes, what is a guardianship? What do you do and how does it work? Once that exam is done, the medical paperwork becomes the outline for what the guardianship is going to look like. So if you say the person can only handle a little bit of money, then they're only going to get a little bit of money left at their discretion. If you can say they can handle a lot, but they just need somebody with oversight, then that's what the court is most likely going to do. The court is going to take in the family history and the extraneous things that are going on, because a lot of times that can be the linchpin, because when they come into your office, they may or may not have an accurate person giving history. So you are operating in a little box, so to speak. So if the people are needing that, that guardianship, and you have that medical affidavit, it gets filed at the courthouse. After it's filed, the ward, the person who's going under guardianship, has an attorney appointed for them. This person is called an attorney ad litem. They'll have a short 1 or 2 page order, and it just says that they've been appointed to represent Mrs. Smith in the guardianship process. When they present you with that order, it may or may not say that they have access to medical records, but the statute is clear. They have access to every medical and financial record. So you may have to run it by legal, but you are going to have to reveal records. And it's much easier on you if you'll help the ad litem by getting those records to them early, and oftentimes can help you avoid that subpoena that most physicians and medical staff dread. So that ad litem does have authority by statute to have any and all medical records. The other person that may or may not be appointed at the upshot is what's called a guardian ad litem. And this person is oftentimes appointed when there's a conflict or conflicting information, or when the court says, I don't really have enough information and I want to know more before I make a decision. The guardian ad litem has a specific job given to them by the court, and their job is to look out for the proposed ward's best interest, as opposed to what the ward wants. The attorney ad litem has to advocate for what that person wants. So when Mrs. Smith says, I don't want a guardianship, the attorney ad litem is going to come into court and advocate against the guardianship. When the guardian ad litem gets involved, it's probably because the court wants more information or Mrs. Smith is contesting. And if the court wants more information, it may be viewed that if they have a guardian ad litem appointed to get medical records, it can short-circuit what's going on, and we can either make a decision, we go forward, or stop the guardianship because there are other alternatives where Mrs. Smith doesn't need the guardianship. After this has all happened and the medical records are gathered and there's been a 10-day waiting period, then you can have a hearing on the guardianship. Now, some guardianships, if the ward contests them, can become quite interesting, because what it wraps itself around is the medical evidence on capacity and capacity questions. On the other hand, if you have the kids fighting over who gets to be guardian, then you may have the escalating explosion. So that's when you have the problematic guardianships. And the decision is probably not based on medical, it's going to be based on the circumstances of who's the better qualified candidate. And just like surrogate decision making, there's a statutory priority. The husband is the first to be, or the spouse is most likely to be looked at, then the adult child, then parents, and again, there's a whole statutory lineup. You also have to qualify as guardian. You can't owe the proposed ward money or you're knocked out. So the child who's been stealing the Social Security usually has to come in and fess up, because we'll have the bank records, and that's a great way to disqualify him oftentimes. You can't be a person of notoriously bad conduct. and there's no statutory definition, but that's kind of another outcome. You can't be convicted of a crime. It used to be any crime, but now it's basically a crime of sexual nature, abuse, or theft. And so if you have one of those convictions, you're not going to qualify as guardian. Bankruptcy is usually another one by default because the person can't get a bond if they've had a bankruptcy and you have to get a bond. The court is also going to look at who does this person prefer to be guardian. So you in the medical profession are oftentimes going to hear Mrs. Smith saying, well, I would really like my son or daughter, or I would really like my niece Sally, and that person can either be designated in writing, and if it's in writing prior to the incapacity, it's going to have great weight, or it can be something that they're expressing consistently as a choice. And oftentimes the court will take that into consideration when they're trying to figure out who should be the guardian. The other issue is that often comes up from the medical perspective in the guardianship is Mrs. Smith wants to come to the hearing. And so we're going to turn to you and say, she has the constitutional right to be present. But we also, in Texas, I think, have a fairly common sense attitude toward it. If the person, I remember when the new law went into effect, Judge Marion tells the story of looking out her window and seeing the stretcher being brought into the courtroom because the statute said you had to bring the ward to court. Well, the courts don't want to see the person on the stretcher. What they want is something from the medical physician saying that Mrs. Jones is not capable of physically being present, or Mrs. Jones can't have meaningful participation in the courtroom. They may be able to be there physically and not have meaningful participation. We'll probably want them there. That's good evidence. But we don't want Mrs. Jones, because it's going to jeopardize her care or her mental stability or her health, to be present in the courtroom. That hearing, if it's uncontested, will probably take about 20 minutes, and there's a statutory line that we have to go through to prove it up. After that, the person is appointed guardian and they qualify. And they'll receive what are called letters of guardianship. And you're going to see two types come into your medical practice. The type that you like and the type you don't like. The type you like are what are full and complete guardianships, and they're one-page letters of guardianship issued by the clerk. The ones that you're going to struggle with are going to be temporary guardianship letters and limited guardianship letters, because they're going to say things like, Mrs. Jones is able to participate in her minor medical decision, or her major medical decisions, but not her minor. And you're going to be calling the attorney saying, what does that mean? And we're going to have to say, we don't know, we better go ask the judge. And so those are the ones that are more difficult. But if you get those one-page full guardianship letters, that means there's a complete permanent guardianship. When you get those letters, if they're a temporary guardianship, you need to look at the order and see, does the medical directive remain in place, or has it been suspended during the temporary guardianship? And there's no way to know. It should be stated in that temporary order that it is in effect or it isn't in effect, because the temporary guardianship does not void the medical powers of attorney, the directive to physicians, or the financial power of attorney. If you have permanent letters of guardianship, the medical powers of attorney and the financial powers of attorney are voided by law. So those are out the window. So if you have those in your charts, take them out. They need to be noted on those records somehow, in your medical records, that those are no longer active because there is a guardianship in place. Once the guardianship is in place, the guardian has the decision-making authority for that person. So the hierarchy, when you're looking at this medically, is surrogate decision-making if there are no written directives, and then the thing that voids everything else, surrogates and written directives, are guardianships. So you're going to hope that the person falls in that middle category, having medical directives, and they're not up at the high end with guardianship, and you're not down here scrambling to document your medical charts on surrogate decision-making. The questions that I heard come up, and before I open it up to questions on the floor, I want to address quickly. One was a question about consent to medical research. And I think this is an important question for everybody in this room. And Sue Bean is here from Probate Court too, and I asked her because my gut feeling was, ooh, as a guardian, I don't think you should be consenting to any medical research. And her statement to me was she thought that was also the case. And I think if you're wanting somebody to be a part of medical research, you probably need to have the guardian go down and get court permission. I know that the National Guardianship Association has looked at this in terms of dignity and respect to the ward, and in terms of being part of even dementia studies and things, and they've pretty much come down on the side that they should not be participating in it, and that we should not even be consenting to photos or anything of our wards. And so there's a very protective attitude, and I think that be conservative on whether or not you ask for a guardian to consent to research. I thought I had one more question, but I'm missing it. Anyway, I think the bottom line is in all of this, the goal is to keep the person independent as long as possible. The goal is to make sure that we are doing the least restrictive alternative. Guardianships are like brain surgery. We're not going to go to the courthouse unless everything else has failed. And my moral to you all is, you're the gatekeepers. When you're seeing Mrs. Smith and she is diagnosed with early Alzheimer's, at that point, start talking to her about getting her affairs in order. Be honest with her. Tell her that she needs to do it early. If we're able to see Mrs. Smith in my office, we can have a much happier resolution down the road. 2 years ago, Mr. Smith came into my office. His wife had early Alzheimer's. We were able to get things into a trust. We were able to get all the finances wrapped up. We were able to get the daughter set up so that she could handle medical decisions. They had a mentally retarded son. We were able to take and make care provisions and arrangements for him. Mother went into an Alzheimer's unit about 6 months ago. And then Mr. Smith died about 3 months ago. The daughter now has everything in place. She called yesterday and she said, I'm so glad I was there 2 years ago, because everything is in place and functioning. And had we not been able to see them down at the low end, at this point we'd probably be doing a guardianship for Mrs. Smith, because we wouldn't have a way of handling the finances, paying the nursing home bills without it. And the difference in cost is thousands and thousands of dollars. And the difference in emotional costs and dignity is huge. So please, as the gatekeepers, talk to your families early, get them to elder law attorneys, and help them down the path, not only to get good medical care, but to make sure that the family structure and dignity are preserved. Thank you.
We are ready to break for lunch. Lunch is served at 11:45. 11:45 will be down the hall, and then we'll be back in this room at 1 o'clock for our next presentation. Thank you very much.
I just noticed.
Katie said she would be happy to answer questions if anybody had some, so I'm sorry. Yes.
This is like just a little clarification. You had said something that the older adult has to continue to understand how the power of attorney can spend money, or just at the point of appointing a power of attorney?
Okay, the question is, does the older adult have to continue to understand the power of attorney, or do they have to only understand it at the point? And the answer is both. They only have to understand at the point of signing what they're signing. But the difficulty with the power of attorney is when you have dementia clients, they oftentimes get mad at the child who's helping. And so then they start saying, I don't want my son Joe taking any money out of my bank account. Never mind that Joe's just paying the bills. So what happens at that point is the bank gets upset and they say, wait a minute, we're not going to honor it. And so then the capacity to revoke, you don't have to have capacity, it just gets revoked. So, and practically it gets revoked. So you do have to have capacity at signing, you don't have to have capacity to have it being used. But if you start fighting about it, then it's going to call the capacity into question again.
So the concept of durable power of attorney?
Okay, the question is durable power of attorney. Yes, we write durable powers of attorney, but remember, third parties do not have to honor powers of attorney. So they don't have to say, I take Mrs. Smith's power of attorney. They can say no. And the other thing that you brought up, and I'm glad you reminded me, is in New York, they apparently have some ability to certify that they're valid. We don't have that in Texas. I have been asked to do that for when they've gone to like a brokerage firm, and yes, we'll do that. We'll take the form they provide us and we'll check it out, and if it's accurate, we will certify it. But we don't have that certification process in Texas. So thank you for reminding me.
Okay.
Yes, ma'am.
We have a situation, I work at a VA hospital, we have a lot of dementia unit. We have a veteran there who's on a 90-day commitment. His son did have power of attorney and all that, but of course he wanted to leave the unit, and he's not really just, he's diabetic and has terrible heart disease and has a 3-centimeter lung mass, and it's just a mess. But anyway, he's now on a 90-day commitment, which is about to go out in about 2 weeks, and he's telling all of us that he's going to walk out the door. I assume he came to us from another hospital, so I assume he was on that because the power of attorney did not allow anyone to hold him against his will. He wanted to walk out.
Okay, let's sort this out. She's talking about a ventilator patient who's on
Demented.
Oh, demented. Demented. I'm sorry, I thought you said vent.
He's in a lot of
Okay, I'm hearing. Okay, so he's demented, and because he's demented, probably you need to look at whether or not he's going to continually refuse care, and if that's the case, the family needs to explore whether or not a guardianship is appropriate, because he may not need the level of acute care that you're offering, but a lesser level.
So we could either extend, I actually am in the process of trying to extend the 90 days. That's what we call the court to see really where do we go. But I'm wondering, is this someone who should at some point have a guardianship?
And the answer is maybe. You know, it's a matter of how stable are you going to be able to get them in that mental health commitment period, and is he going to be happy enough in the end? And probably not.
He's probably fine. We think he has a stem cell carcinoma in the lung, but that's just an incidental kind of thing. So does he just keep extending this 90-day thing ad nauseum, or do at some point, you know, we can try to go for guardianship?
You're probably going to wind up with a guardianship because the 90-day is only when he's a danger to himself or others and in a deteriorating condition. And after 90 days, it's pretty uncommon that somebody's not stable enough to be released from that commitment. So I guess in hindsight, it's always perfect, but if this ever happens again, start talking to the family the first day they walk in, not the 65th day or the 75th day, because that 2-week window puts you in the emergency, and as Sue will tell you, they don't want to see us down there for something that we could have prevented, and that's always the hard part.
The other issue is that the complaint we get from families is they cannot afford guardianship. Is there something, you know, that
Public guardian.
to direct families about how to do that early? It makes good sense.
Yes and no. Guardianships are expensive. The way to avoid them is early intervention planning when they're first diagnosed with dementia. People are usually penny wise and pound foolish, and they don't take your advice and they wait for a crisis. And once that crisis occurs, our hands are tied because, as I talked about early in my talk, the capacity level to sign documents is gone. And so if that's gone, then the only choice is guardianship. In terms of low income, Monica Bonilla is here from Catholic Charities, and they run a program for people who qualify, I believe, at the poverty level. So there is assistance for guardianships, but that is the person, the ward. And oftentimes the families do not accept the fact that assets include houses, income, and the $30,000 that was always promised to them. And the message that they're going to hear from the court is that $30,000 is mama's, and the house is mama's, and that's to be used for mama's care. So yes, guardianships are expensive. There's really no way around it. I think initiating a guardianship, the court fees and the service fees and just the expenses run about $450, and that's before you've even paid an attorney. And, you know, when we have a son or daughter who's avoiding service because they've got child custody things, and we wind up having to pay $150 instead of $60 for service, you know, it just keeps going up. And so those are the kinds of things that we can't do anything about.
So for a family, say, to start a guardianship, they need to get an attorney or go down to the court and file certain papers, or how do
You
you do
have to have an attorney. And Sue is sitting there shaking her head saying, do not send them to me. The court cannot initiate a guardianship. They have to go to a private attorney. Your best referral sources, I believe, are the National Academy of Elder Laws has a website. You can type in a zip code and you'll come up with attorneys. I believe there's a reason people are certified, and I think certified elder law attorneys or board certified estate planning attorneys are probably the people you want to start with. Estate planning attorneys usually say, guardianships, that's the dirty stepchild. I don't do those. So I think you're going to find there aren't that many people in San Antonio or even in Texas doing guardianships. Any other questions? Thank you all.